Good afternoon, everyone. So we are very close to the cocktail hour. So this is going to be the happy hour, I guess. Yeah. It's interesting that I decided on this topic to talk about proving alienation without experts in a conference that is full of experts. But before we go on, let me tell you what it's not about. This is not about an argument that experts are not needed or that having experts is a waste of time or money. By all means, a good expert can make a huge amount of difference in a case and can explain to the court the dynamics of alienation, what's going on in the case, and help the judge make the right decision. But I've been thinking about this for the past several years, and I teach at judicial conferences as well. And one of the most common refrain that I hear from the judges across the country is, we don't have the resources. Majority of the parents, litigants in front of me are pro se, they represent themselves. So we don't even have lawyers representing these parents. We don't have guardian ad litem. We sometimes don't have resources to order custody evaluation because our parent can't pay for it. And time's running by. And as judges, we are overwhelmed with all these motions and the research that is thrown at us from both sides. What can I do as a judge, as a trier of fact, that can make a difference and that can make a timely difference? So I've been thinking about this, and this is what this presentation is about. It's a dialogue. I certainly don't have any answers, but Judge Van Allsburg has been very kind to join me here, and is one of the few judges who have had detailed opinions published on parental alienation and has been affirmed by the Court of Appeals on that. And I've had the privilege to practice before him and try cases involving alienation, but also try cases involving false allegations of alienation, which were part of abusive behavior as well. So let's talk about what these cases look like. In any divorce case, there is bound to be some conflict. Our Anglo-American system of justice is in fact based on adversarial system, and there has to be some conflict to go before a judge, a controversy, something they can decide on. So that's not unusual. But in a healthy conflict, people are looking for resolutions. They want to get to some place, they want to get out of the court, they want to move on with their lives. In cases involving alienation, it happens sometimes to be the toxic conflict, where the parents, the litigants, the children, and the professionals are so mired in the conflict that the conflict itself becomes a destination. There's nowhere to go, and people keep on throwing the labels around. This is a great book. If you haven't read it, please take a look at it, by Amanda Ripley. It's about high conflict cases and how to get out of toxic conflict situations. It's not just about court and litigation, but it talks about conflict in general and provides some really good solutions. What happens in cases involving alienation is people get wedded to scenarios. They see what they want to see. They hear what they want to hear. And pretty soon, we have what's called narrative echo chambers. We have silos of groups conflicting with each other, each with a narrative, each with a label. And that's what makes these cases toxic. Social media has done an enormous amount of damage to how cases involving parental alienation are litigated in courtrooms. Let's take a look at some of the groups that are out on social media and how they deal with this situation. But before we go there, it's important to remember that you have to differentiate as a litigant or as a lawyer between the signal and the noise. The signal is relevant, meaningful information that your judge needs as a trier of fact to give you the help that you need, that your children need. Noise is unwarranted, useless information that only distracts you from the help that you need the most. So when litigants come into the court, one party alleges alienation sometimes, other party alleges domestic violence or abusive behavior. One party claims parental alienation is child abuse. The response is parental alienation is a hoax, doesn't exist, and pretty often special interest groups get involved. So we have fathers' rights groups, which sometimes clients join on the social media and start posting about their cases, about the judges, about the guardian ad litems, about whatever's going on in the case. I've had situations where parents have been sanctioned by the court for posting court filings on social media. California has a very interesting case where a lawyer was sanctioned for thousands of dollars for unauthorized disclosure of child custody evaluation report. And some states are very, very careful in how you can use information that is obtained in court, in litigation that deals with minor children. So when clients are hurting, when the parents are not getting the relief that they want, they lash out. Other groups are mothers' rights group, where they have this other tactics about calling out men as abusive, reaching out to professionals who get involved in the case, intimidating people who are involved in the situation, including the judges, the professionals. Yes, you see your name, Linda, right there. So that's one of the posts where they say, watch Linda Gottlieb testify.
Notice that they never say that case was dismissed with prejudice.
Let's go and watch this particular judge hold an evidentiary hearing. So these tactics, I mean, this is all noise that really distracts you from getting where you need to be. And my first question to Judge Van Allsburg is, how do you deal with these situations where you are faced with such noise, where there are threats being made, intimidation, challenges, letters being sent to legislators complaining about judges? What do you do about that?
Well, first of all, you have to have a thick skin to be a public official, especially these days. I think I'm on both walls of shame, both the fathers' rights groups and the mothers' rights groups.
Me too.
Have me up there for various reasons. And unfortunately, the healthcare professionals find themselves attacked as well. I tell attorneys in family law cases that the kids probably need a counselor, but I don't want to hear from that counselor. The problem with this is that attorneys will call the child's counselor in to testify, and in the course of doing so, they destroy the trust and rapport that the counselor has developed with the child, and many counselors quit once they receive their first subpoena. And so trying to find a counselor for a child whose family is caught up in a family law case is getting more and more difficult, and that's a real problem. And I'm sure you can all see that.
And that leads to this false notion of dad versus mom, or mom versus dad. And when we have court decisions from various courts in the US that this is not a gender war. Parental alienation is a behavior that is found across the board where women have engaged in it, men have engaged in it, and it's not a simplistic analysis of gender. But once this notion takes place about as some sort of a rush to get to a binary solution, that's where things get even more complicated and toxic at times, because the parent, the litigant, the client feels that in order to win, and I don't see winning in family courts by any definition, but in order to win, you need the top-notch expert. So in comes the expert cavalry. And in come all the different labels and nomenclature, PAS, PA, RRD, PCCP, PTSD, and people file motions after motions attaching research papers, literature, and everything is thrown to the trial judge. Now, the important thing to note here is that all of these experts have peer-reviewed publications. So it's not to say that one is better than the others or this or that, but it's how this research and writings are used in a court of law. I think Dr. Harmon has already mentioned, and she has written about how some of her writings have been misused and misrepresented in litigation. And I see this oftentimes. Someone claims Richard Warshak wrote X, Y, and Z and claimed A, B, and C. No, he didn't. But this is just thrown against a trial judge who doesn't know really what to do with it because it's not evidence. And it leads to, down the road, a battle of experts. And then you have a trial within a trial because one party claims, Judge, I want a Daubert hearing. I want a Fry hearing. Mom's complaining about parental alienation, and that's completely a hoax. I want a trial to demonstrate that parental alienation doesn't exist. And you are looking at an expensive trial. You're looking at a time-consuming trial. All the while, precious time is being lost, and the child continues to age out. So my question to you, Judge, is do you need an expert to tell you that parental alienation exists in a case?
No. No.
And
I've had quite a few parental alienation cases over the years. I'm in my 21st year on the bench. And early in my career, and I came out of a private law practice where I had litigated family law and other kinds of cases. So I ran for the court. I was elected in 2004, and immediately started learning more about this issue. And the big controversy at that time was whether parental alienation was a syndrome or not. And I concluded pretty early on that there's no evidence that it is a syndrome. The efforts to make it a syndrome, that is a medical diagnosis, had not succeeded. And parental alienation is at its core bad behavior. And so that's the way we hear evidence about it. Most of my cases, and I think this is true everywhere, most family law cases involve parents who are not represented by attorneys. They're coming in on their own. They wouldn't know how to hire an expert even if they could afford one. And so judges are left to hear what's happened in the case. Who said what, who did what, and when, and then draw conclusions from that. So I have been deciding cases involving allegations of parental alienation for years, and most of them have been without experts.
And have you found that in the past decade or so, there's been a significant increase in court filings by litigants using different labels? You know, gaslighting, narcissist, alienator, abusive. It's almost as if people go shopping for these labels and sprinkle the court filings with all these different terms. And then they go and try to find an expert who is going to agree to their theory. So it's backwards in a way. It's a theory in search of facts rather than it being the other way around. And we don't need this. You don't need to prove in a court of law that one parent is a narcissist in order to draw the court's attention to the behaviors at issue. Just talk about the behaviors. If there is evidence of a parent interfering with parenting time, denigrating the other parent, using some alienating strategies, just talk about the strategies that are in front of us, instead of using the terms and labels and trying to make the case unnecessarily toxic or adversarial than it already is. In my opinion, labels divide us, stories unite us.
And I'll add, labels don't give us any basis on which to make a ruling.
Exactly.
It's the facts that give us that ability.
So here's an interesting case from Ontario Superior Court. Is Brian Ludmer here? He's not, but he was the attorney for the alienated parent in this case who got this really wonderful ruling. And this is a case where the court held that we don't need an expert to tell us whether parental alienation exists in a case or not. A trial judge can make a finding of parental alienation based on facts alone. And there are several cases of similar nature in Canada, in the UK, in the US as well. Judge Van Allsburg had a very interesting case, Martin versus Martin in Michigan, which went through a very complex trial, a multi-day trial, and it's the only case in the state of Michigan that's a published opinion by Court of Appeals. And in that case, the Court of Appeals agreed with Judge Van Allsburg that while there may be some controversy regarding the syndrome or some terms, there is no debate about the behaviors. Judge, can you a little bit talk about that case a little bit?
The case dated back to 2009. The parties went through a high conflict divorce. I found at the time that mom was alienating the kids from dad, but dad was also a mean and vindictive person and had caused his own estrangement from the kids, which mom took full advantage of. So at the time, they were ordered into counseling. When the judgment was entered after trial, mom ended up with custody. Dad had parenting time, but they were subject to counseling orders. It didn't happen. And as is often the case, I didn't know that. At the time I entered my judgment, no one filed any motions after that. No one came back to the court. For 3.5 years, Dad simply dropped out of the picture and did not exercise parenting time. And by the time the case came back in 2014, I found then that Dad, instead of trying to force his way back into the kids' lives, had really gone to work on himself. He had been involved in continuous weekly therapy for 3.5 years. He had gone through parenting classes. He had a personal coach. And so when he came back in, he was essentially a changed person. His attitudes were different, and he wanted to try and reestablish a relationship with his kids. Mom had not changed. She was still hostile and opposed. And we ended up going through some reunification therapy. I had to order enforcement or take enforcement measures. Mom ultimately ended up, I think, spending 9 days in jail for violation of orders to participate in reunification counseling. And after that happened, Dad filed a motion for change of custody. By then, there were 3 kids. The 2 older boys had aged out. We had 1 younger daughter, still subject to jurisdiction of the court. And we went through a custody trial, and the parties were represented. I ended up changing custody of the youngest daughter to Dad, and I ended up having to enter further enforcement orders. Daughter was engaged in some extracurricular activities, although she had to change schools. The extracurricular activity folks were too closely tied into Mom, and so it became a real issue. So I had to pull her out of a couple of activities. But she ended up having a reasonable relationship with Dad. She got along well with him after all of that. Mom has untreated mental health issues and has no incentive or interest in treating them. But that case, we had expert testimony. It went up on appeal. Mom claimed through an attorney at that point that parental alienation was junk science. And the Court of Appeals, as you can see in this quote from the case, they did not comment on whether there was a syndrome or not, but they said there's no reasonable dispute that high conflict custody disputes frequently involve acts by one parent designed to obstruct or sabotage the opposing parent's relationship with the child. Pretty plain statement of what's at issue here. It's, as I said before, simply bad behavior, and you can take testimony from the parties. You don't have to have experts, experts can be helpful in laying out the details and organizing the information and fleshing out the details where parents often don't. And so that's my position in the case, and I've been asked to share that opinion with other judges around the state. So I think there's a consensus developing, at least among the judges I know. I serve on the Family Law Committee of the Michigan Judges Association, and we've had these conversations.
Okay. And if any of you want to read that opinion, it's part of the public record. I'll be happy to share it with you. Send me an email. I would like to follow up on one thing that Judge mentioned about the alienating parent spending time in jail. I have seen judges do this across the country, but it's not often. In fact, it's rare. And the only way to change the alienating dynamic and to stop the parent from continuing in alienating behavior is to ask and obtain consequences for bad behavior. No one gets sent to jail for parental alienation, but litigants and parents get sanctioned and also get sent to jail for contempt of the court. And for that, you need clear, well-written, detailed court orders.
I was telling you over lunch as we were talking about preparing for this, I've never sent anyone to jail for parental alienation. What I have done is sent parents to jail for violating orders to participate in reunification counseling, for failing to sign the children up for reunification counseling, for violating the specific terms of the orders that are intended to deal with the problem. In Michigan, we have a statute that says a violation of a child support order or a parenting time order can result in a contempt of court sanction. If the court finds a violation of an order, the court shall issue a contempt citation unless there's good cause to excuse the violation. And so we have arguments over whether there's good cause shown or not. And if not, I find contempt. Fines in Michigan are limited to $100. If it's a bad faith violation, I can add a financial sanction, $250 the first time, $500 the second, $1,000 for every violation thereafter, and I can also order attorney fees, and that's a significant sanction, at least where there are attorneys involved. I can also send people to jail for up to 45 days on a first offense, up to 90 days on a second or later offense. So I remind people of the potential sanctions for violation of court orders dozens, if not hundreds of times a year. And so because I let them know that that's a distinct possibility, I think that reduces the number of violations, but there are times when you have to bring the hammer down in order to retain credibility in the case, and so some people go to jail. And I have handed out the max before, 90 days. Not often. I can probably count them on one hand.
Okay. And this is not just Michigan. We have cases from New York. We have cases from other states, Arkansas. We have other cases from Connecticut as well. And they all talk about the focus on the behaviors. And whenever a parent has made an argument that the trial judge was wrong in finding parental alienation because there wasn't any expert testimony, the Court of Appeals have usually struck that argument down. That no, a finder of fact doesn't need an expert. There doesn't need to be a debate. There doesn't need to be a trial on whether parental alienation syndrome is real, whether the term is in DSM-5, whether there's published research supporting the theory or not. What we need to look at are behaviors and apply common sense logic. The behavior at issue, is this behavior harmful to the child and the child's relationship with the other parent? But let me ask you, Judge, if there is no expert in front of you telling you what parental alienation is or what the term alienation means, how do you define the term? What do you understand by the term?
Well, because parental alienation is not defined by statute, the typical resort is to the common language. You look up the terms in a dictionary, define parental, define alienation, define the terms together, and then you look at the conduct, the words in the conduct, and make decisions as to whether it constitutes parental alienation or not.
Okay. And when we look at these cases where the courts have intervened, and some of them did have expert testimony, but when you look at the decision and you distill the persuasiveness of the evidence, you see that the court has been persuaded by behaviors. What the alienating parent did, how did that affect the child? How did that affect the child's relationship with the other parent? Were there violation of court orders? And these are facts that need to be litigated and provided to the court in terms of evidence. The reason sometimes getting an expert and using an expert in a case backfires at times is because of the amount of time that it takes for the case to go to a trial. Because let's say you get a really good expert who looks at evidence, who decides, okay, there's alienation involved, and you ask for an evidentiary hearing, you have the expert report. The other side wants time to get a counter-expert. They need months to get an expert to battle your expert. There are depositions. There are counter-expert reports. And by the time the trial rolls around, it's 9 months, 10 months, 12 months, often more. And the child continues to age out. It's even worse if the targeted parent has no or limited contact with the child during this time. Because then we have a new normal. We have a situation where the child hasn't seen a parent in a long time. And what do you do about that, Judge, when you have a situation like that?
Well, let me explain how we handle things in Michigan. Our Supreme Court has adopted case management guidelines, which, as they apply to family cases, say that 75% of our divorce cases should be completed with children, should be completed within 10 months, 98% within a year. And it used to be 100% when they first adopted guidelines. There was a lot of pushback about that because we all have outliers. I had a case that went to trial after 11 months, or was supposed to. One of the parents filed a bankruptcy petition in the federal bankruptcy court the night before the trial, and that froze us. We couldn't do anything. So that case went over a year. And so I've had several that have gone longer than a year, but we work very hard to get our cases completed in the time allotted to us. And going back to your question about, I may have lost the thread of your question here. What was it?
What do you do when you have expert and a counter-expert and battle of experts in front of you? How do you decide where the focus needs to be?
I, first of all, have to have the expert qualified. Most cases that's not difficult. Many times the attorneys stipulate to the qualifications of their opposing experts, and I will listen to what they have to say. But frankly, most experts are drawing their conclusions from what they've learned about the case in preparing for trial. So a lot of the information begins with the parents, and they're simply bringing it into court and laying it out in a format that may be helpful in evaluating the evidence. When I was talking about the Martin case, we were not using the five-factor model then, and neither parties were both represented by attorneys. They both brought in mental health experts. No one raised the five-factor model as an issue to aid in evaluation. That was a 2019 trial. In 2020, I had another case involving parental alienation. I had experts in that case, and they did bring the five-factor model in. And there was an objection that it was junk science, and so I had to conduct a Daubert hearing, which we did right in the course of the trial. And this was during COVID, so the case was set for a week of trial in first week of April 2020. The courthouse shut down mid-March, and so we were all learning Zoom as fast as we could. But no one was ready for the first week of April, so we ended up adjourning. We started the trial, I think a month or two later. We tried that case on Zoom over 13 days and 3 months. And it was quite a nightmare, but we got it done. We got all the testimony in. Nothing took place in the courtroom, although during COVID, I still went to the courthouse every day. I had my own key. So I was there sitting in an empty courtroom. having everybody on screen in front of me, and we conducted the trial that way. And I did a daubered analysis of the five-factor test and approved it, found it admissible. But I wrote in my opinion, which ended up being over 80 pages long, I said that whether or not parental alienation is a syndrome or a disorder does not matter here, as no diagnosis has been found or suggested. The issue here is how to evaluate the facts in this case that support a finding that alienating conduct either has occurred or is occurring. And in that case, I did find that mom was alienating the kids against dad. I ordered a 90-day change of custody with some intensive therapy. Unfortunately, in that case, and I had personality profiles, evaluations that had been done. Dad was rather high on the histrionic elevation, and so he was very reactive and very impulsive and did not handle rejection well. So he could have made this work, but I think that he was his own worst enemy in terms of that, and it made the alienation process very easy for mom. So we're still dealing with that case. The kids, only one of the two kids is aged out at this point. And just to comment about that, I'm one of 3 family judges out of 5 circuit judges in my county of about over 300,000 people. And the thing about family cases is that we're not just dealing with the family from complaint until the entry of the divorce judgment. We keep those cases, and they keep coming back until the children have aged out of the system. So we get cases that carry on and last for 15, 18 years. And we currently have something like 11,000 children under the jurisdiction of the court from various family cases that have been filed over the last 18 years. And they come in at the rate of about, 1,000 divorce cases a year, and even more custody, support, parenting time cases, because it may be true in most places, as it is in our county, that more children are born out of wedlock than in a marriage these days.
So let's talk about storytelling. When a parent is complaining about alienation, usually the parent is trying to change custody, trying to modify parenting time, or trying to get some mental health intervention, or a combination of all of this. And in all jurisdictions, judges follow what's known as the best interest factors as to what should be done in the situation and what's in the best interest of the child or children. And Michigan has its own factors, and which are very similar to different states in the US. They call it by different terms in different nomenclature, but ultimately we are looking at the similar factors here. So Judge Van Allsburg, when a parent complains to you that he or she is being alienated against the child by the other parent, what's the most persuasive evidence to you? What do you look for?
Well, there are a number of factors. We've got 12 factors in Michigan, actually 11 plus any other factor the court finds relevant is the 12th one. And we are required to consider the sum total of the factors to be considered, evaluated, and determined by the court, is what the statute says. And some of these factors relate directly to issues of alienation. In fact, one of them that everybody understands as relevant is what we call factor J, and I'm going to pull the actual language up here. The willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. That clearly applies here. There was a sentence added a few years ago to this factor which says, a court may not consider negatively for the purposes of this factor any reasonable action taken by a parent to protect a child or that parent from sexual assault or domestic violence by the child's other parent. And that is an indicator of the ongoing conflict between folks who are on the domestic violence side of this issue as opposed to those who are on the parental alienation side. There's hardcore resistance at the extreme edges on either side about how domestic violence and parental alienation should be analyzed when one or both are raised. And frankly, if one of those issues is raised in a case, it's very likely the other one will be raised also.
Let me ask you about a different thing, and this comes across in more cases these days than it used to. A parent is very keen to show the trial judge video recordings or audio recordings. And often these recordings show the other parent engaging in some bad behavior, questionable parenting, yelling, screaming. And at times it's helpful, at times it backfires. So, Judge, have you seen these recordings where one parent brings to you and say, look how the other parent is treating me in front of the child?
Many times. I've had cases where both parents have brought in videos, and it turns out they have screaming fights in front of their kids while each of them is recording the other in front of the children. So you can hear the children crying. You can hear the awful things that each of the parents is saying to the other. And this evidence is often detrimental to both parties because it indicates how awful the breakdown of the marriage was and how much the children were exposed to. Sometimes they show bad behavior on one side exclusively, but generally, more often than not, you see bad behavior from both parents because they're recorded prior to separation as the marriage is breaking down. It's in its worst stage, and the parents are busy recording. We also get a lot of journaling that parents will do, and you've all heard the recommendation, document everything. And I endorse that. But what happens then is that one parent wants to obtain the other parent's journals. Sometimes they task the children with stealing them, but other times they hire forensic experts and they want to see the phones and the laptops and download it all. I found that when parents do that and offer the other parent's journals into evidence, they can come in because they're identified and they're an exclusion in Michigan from the hearsay rule because they're offered against the other parent rather than offered by that parent in support of their own position. But I find many times that these are counterproductive. They tend to document well what's going on, and so I quote from them in the opinions where relevant.
When you are faced with two narratives, one parent alleging alienation and the other parent alleging, let's say, protective gatekeeping. Mm-hmm. I'm not alienating, I'm only protecting my child. The other parent is abusive, lacks empathy, etc. How do you gauge credibility as a trial judge?
Well, you listen to each of their narratives and you watch those narratives unfold. You pay attention to how much detail is provided, and if there's a denial that something happened, you look at the detail associated with the denial. Many times I get admissions that the incident occurred, it just didn't happen the way the other parent said. So I have to compare their respective narratives about what happened and make a decision as to which party is more credible. And that's a skill that hopefully develops as you gain experience in these matters, and I still have second thoughts about my own ability to assess credibility, even though I have to do it constantly. But you also look for corroborating evidence that either corroborates or fails to corroborate one parent's story.
Do you believe that the earlier you get an opportunity to look at the family dynamics and the allegations of alienation, the better it is for the family?
Theoretically, that's true. And I attended the session on fast-tracking parental alienation cases. That requires upfront an analysis. And in our court, we do have an early conference with our friend of the court, either investigator or custody evaluator, and these are folks who work for the court and are on staff. We get parties in to talk about custody, parenting time, and support issues within a month of a case being filed. And they interview the parties together if appropriate, separately if not. Sometimes they're pending criminal charges or orders of protection and no contact orders, and we do those interviews separately. But if the parties cannot reach an agreement with the help of the friend of the court, then the friend of the court evaluator will make a recommendation as to what the initial interim order should read. And then both parties have an opportunity to object, and then they can come into court about that. But it helps to put some ground rules in place, and every one of those interim orders that's entered says what the best or what the inherent rights of the child are. We've got a paragraph that says neither parent shall do anything to undermine the relationship of the child and the other parent, and that can serve as a basis for a contempt finding if it's violated. So we put that in every single order and judgment.
And that's what matters, findings of the court. Because without the findings made by a trial judge, all you have is allegations. And that's just talk. I don't know if my friend Tony's in the room, but he's often complaining that people talk. Lawyers talk a lot. Everyone talks, but nothing happens. And that you see this in cases because sometimes cases are litigated very, very aggressively. You see the court's motion filing docket with pages and volumes of material. But it's astounding that there's never been an evidentiary hearing. There's never been a trial. There have been no findings of fact. They're just allegations thrown around. So,
And even that initial conference with a friend of the court, there are no findings there. There are some statements of the friend of the court caseworker about what the parties told them during this conference, but that's not evidence for the court. That's just a basis for entry of the interim order, and if either party objects, then we have a hearing. And we can take some testimony there, but it won't be a long hearing. It won't be as long as a trial. It may be an hour. It might be 2 at most. So it's difficult to get enough detail and enough context of the family history in the course of a short evidentiary hearing to know that you are really on the right path. And that's the difficulty that we face. Many times, judges don't even see the parties for the first time in court until 6 months down the road. They've met with a friend of the court. There's an interim order in place. They may have gone back for a review hearing on that interim order in front of a referee, and there may have been an amended order issued. But by the time they get to the court to determine what's going to happen next, are we going to set a trial date or are we going to send the parties to mediation? 6 months has gone by. So in this case that I was telling you about that took place on Zoom during COVID, I wrote an opinion. It took me several months to get it together, and I'm just going to read the footnote where I apologize to the parties for the delay in completing the opinion. I said, however, the court's evaluation of the evidence was delayed by the submission of 93 exhibits out of 123 offered, one of which was an unindexed collection of binders totaling 1,925 pages. These were texts and emails and everything else. And another consisting of over 50 pages of text messages, most of which were not referenced during the trial, but they were admitted, so I had to review them. And of course, you know, all these exhibits come in during trial, and you're listening to testimony. You can't review exhibits at the same time you're listening to testimony. So the examination of the evidence that comes in generally comes at the end of the trial. And so I wrote, the court's ability to review and analyze such information is limited to occasional unscheduled office time during the workday, of which there is little, and available nights and weekends. So that's what's happening after the trial is over and you're waiting for the court's opinion. You're waiting for the judge to get some free time. I typically don't get to write opinions during the day because I'm fully scheduled in the courtroom. And every now and then I have a case that settles at the very last minute. So, you know, I pull out what's waiting on the credenza behind my desk and start working on it. But that's what we're dealing with as we try and move these cases forward.
Okay. I want to address one issue before we open the floor for questions. And Much like the best interest factors for custody, we have parenting time factors in Michigan as well, which a judge looks at when awarding parenting time to a parent. And one of the issue is detention of a child by one parent against the other parent. And that's a hallmark of many alienation cases where the alienating or the favored parent tells the court, of course I want little Johnny to see the other parent, but he refuses to go. What do you want me to do? Force him, drag him, put him in a car? And judge, what do you do when such arguments are made and you find out that your parenting time orders are not followed?
Well, I have to wait for someone to file something. And typically that's called a motion in order to show cause why the other party should not be held in contempt of court for violating a court order. We call those show cause orders. And I look at the motion, has to be supported by affidavit, and I review the facts that are alleged. And if it appears that there's a violation, credible violation alleged, then I will sign that order, and there's a hearing scheduled, and the parties show up a couple of weeks down the road, probably 3, maybe 4 weeks down the road, depending on how much time the attorney is asking for. And then we take testimony at that hearing and determine whether there's been a violation or not. That is in the cases where a motion in order to show cause is filed. I hear far more alleged violations where no one files a motion in order to show cause, so it never comes in front of the court. And I can't enforce the order unless that happens.
Have you had any experience where the targeted parent or the rejected parent has tried to involve law enforcement to obtain the child's custody or to get parenting time?
Yes, and this came up at our, we do quarterly judges meetings with all the judges in the county. So at our June meeting, we had a question from our sheriff who was getting pushback from the bar about not sending deputies to parenting time complaints. So I'll read you what I wrote. I actually met with my fellow judges. We put this statement together and sent it off to our sheriff, and it was shared with all our police chiefs and law enforcement throughout the county. I wrote, our general advice is that county law enforcement, including sheriff, police, and public safety departments, have no obligation to enforce civil court orders. The exceptions include the direct order of a court, typically issued in the form of bench warrants, contempt orders, or pickup orders, and the specific exceptions noted below. And I wrote a law enforcement response to complaints alleging nonviolent violations of custody or parenting time orders is often contrary to the best interests of the affected children, as the involvement of law enforcement often escalates the animosity between the adults involved and increases the risk of emotional trauma to the child. In the absence of the exceptions noted below, judges do not expect law enforcement personnel to write reports regarding custody or parenting time violations. Persons reporting violations of custody and parenting time orders should instead be referred to the Ottawa County Friend of the Court. That's the arm of the court I told you about. They have a statutory obligation to enforce the court's custody and parenting time orders. I wrote, writing reports without a specific law enforcement justification exposes law enforcement personnel to unnecessary subpoenas, creating an obligation to appear and testify about who said what in family court cases. I noted there are some exceptions to the general advice. First, any allegations of violence or threats of violence, the abuse or neglect of a child, or any other allegations involving violations of the penal code or a breach of the peace, such as would justify a response to any complaint alleging domestic violence. Second, alleged violation of a personal protection order. And third, an alleged violation of a statute, MCL 750. And I'll simply read that to you since may be unique to Michigan. Some other states may have this. A child's parent, the statute says, shall not take that child or retain that child for more than 24 hours with the intent to detain or conceal the child from any other parent or legal guardian who has custody or parenting time rights under a lawful court order at the time of the taking or retention. So 24 hours triggers a legitimate criminal complaint in Michigan for harboring a child in violation of a custody or parenting time order. The statute makes that a felony, punishable by imprisonment for not more than a year and a day, or a fine of not more than $2,000 or both. Now, caveat, you have to find a prosecutor willing to charge that offense. So,
But even if you can't, you can still file an order to show cause in the family court and bring the matter before the trial judge or the family judge to get some accountability, right?
yes.
Okay.
Yeah, I can send them to jail for 45 or 90 days, depending on whether it's a first or second offense. I can't send them to jail for a year and a day.
That's too bad. Okay. So here are the references and a shameless plug from my book, which is the best book on parental alienation,
Good
if
book.
you don't know.